she attempted presenting the topic, methods of initiating criminal proceedings. This question is not the same thing as arrest. Rather, is a question that tasks you to tell us, after this arrest has been made, what next do you do? Assuming this arrest has been made, and there is a prima facie case that this person, this suspect, might have committed the offense. We have to be speculative about it because the law of presumption, the constitution of presumption was innocent until the contrary is proven. So he is being charged to court under a probability that he might have been the person who committed it, even if you had seen him with your eyes committing the offense. But because you are under a duty to respect the Constitution, which says don't reach conclusions, rather do what? Prove it against him. Rather prove it against him. Now, let's look at a scenario where this investigation has been concluded and there is evidence to show that at least this person might have committed an offense. How do we take him to court? How do we charge him in court? Now, first of all, you want to look at what offense has this person committed. That's the primary thing you have to take into view before you start thinking of the court with the requisite jurisdiction. You first of all find out, is it a matter that the magistrate has jurisdiction to entertain, or a matter that the magistrate cannot entertain at all? So, when you resolve that issue, it will now tell you the next thing to do. Even if it's an offense, the offense being suspected to have been committed by this person, it's such an offense that can only be entertained by a high court or a federal high court. What do you do? The person who first of all be done what? We are arraigned in the magistrate court. We be arraigned in the magistrate court first. So if the magistrate does not have jurisdiction, by the excellent provisions of the Administration of Criminal Justice Act, the magistrate will simply make an inquiry to find out what did you say he committed, where was it committed. I will also tell you another importance of that inquiry. So if the magistrate is satisfied upon inquiry that this person seems to have committed the offense for which he has been charged, the magistrate will write it that the defendant has been arraigned before him on the social count charge, burden on social offense, over which the magistrate has no jurisdiction. Then the magistrate will now make orders that the case file be transmitted to the Director of Public Prosecutions, and we give a date as a return date for report while remanding the defendant in the prison custody. So this is basic. Then as we go on, I will now tell you, how. Now, but at this stage, he is summoned or brought to court by way of charge sheet. Then a charge sheet simply means a document on which the offences alleged against the defendant is contained, and which also contains the date of arraignment, conditions for bail venue, the name of the prosecuting officer, and then the order made in respect of bail. A charge sheet comprises of counts, that is the offences, the count, the offences the person has committed. So when you see a charge sheet like a document like this, the offense that he has committed, number one, could be count one, that you, so person, in the company of some other persons at large, on the so date at so place within this magisterial district did conspire amongst yourself to commit maybe a misdemeanor or an offense. That count, the first count now is a count on what? Conspiracy. Are you listening? Yes. That's a count on conspiracy. And then maybe count 2, we now hit what the person did. We now talk about what the person did. That you, Mr. So, and some other persons now at large, on so date, within this magisterial district, did break into a living house at midnight, or broke into a living house belonging to Mr. XYZ at so time of the night, if it's available. That offense now is offense of what? Breaking, house breaking, breaking an entry is an offense itself. What I'm teaching you this is that when we start to do charge itself, you won't make mistake, you understand it. First one, they conspire to commit a criminal offense. Second one is the fact that they broke into somebody's house at night. Breaking in the daytime is different from breaking in the night, and their punishments are not the same. That of breaking in the night is more grievous than that of breaking into in the day. Now, when they broke into the dwelling house, what did they do? Count 3. That you, the same sentence starts to run down. On so time, at so date, at so place, did break into the house belonging to Mr. XYZ, entered into it, and did steal. You now enumerate all those things they stole. Valued as so much, contrary to section so of the criminal code law of Abia State, and punishable under section so of the criminal code law of Abia. So you are now seeing a charge sheet containing the offense, containing the law which created that offense, and as well as what the value of what was stolen. Right. Now, this is a charge sheet. Because every magistrate court is a court of summary jurisdiction, criminal offenses are tried at the magistrate court level by what? Charge sheets. Now, remember, I was giving you an example of somebody who committed like a capital offense over which the magistrate had no jurisdiction. So it first of all comes to the magistrate by way of what? Charge sheet. And the magistrate will do what? Decline jurisdiction. Then make an order that this file be taken to DPP, and then also makes a further order that the DPP's office should report to the magistrate on so date concerning their compliance. Now, what is the essence of that report? Why would you decline jurisdiction, send the defendant to prison awaiting trial, and then also adjourn the date, adjourn the matter to a specific date? Who will tell me what is the underlying philosophical basis of this very provision of the law? Why is it like that? Why must the DPP report to the magistrate?
So I think that it's for the magistrate, for the magistrate court to ensure that the person is not abandoned in detention, but DPP is kind of the action against the person.
Because in some of the times, police will just arrest somebody and dump the person there. You know, and just charge you with that capital offense. I'm also coming back to it, and the person will now be languishing in jail. So one of the things that Aja has done is to ensure that such a situation doesn't occur again, and also to ensure that every order made by the magistrate is being followed to the letter. And then again, to also monitor the progress of the prosecution, the criminal litigation. So the magistrate needs to monitor it until at a particular point in time, if the magistrate feels that prosecution is not serious, the magistrate can do what? Strike out the charge and discharge the person. Even though on the face of the charge, the magistrate does not have jurisdiction. Are you following me? And that is also why, assuming the magistrate does not do it, and is your client, and you are angry, my client has been going to court for 3 years, and the DPP has not reported anything. What do? You file a motion for his bail on the ground that there is what exceptional circumstance. The law says 3 months for capital offences, but here you see somebody has stayed up to 3 years instead of 3 months. So the High Court will now do what? Bail. Or the magistrate can now look at it and say there is nothing there, strike it out. That's also one of the reasons for inquiry. I'll give you another example. If a charge is bogus, or a magistrate hearing a matter had this argument that this charge before you is bogus, the magistrate is under the law entitled to do what? Listen and do what? Decide whether this is bogus or not by doing what? Making inquiries. It shows you the idea of referring a matter over which the magistrate has no jurisdiction to the DPP is for the DPP to do what? To verify if there is an offense committed. The DPP will simply do what? Report. There is a prima facie offense committed, and we are filing information against the defendant. At that point in time, the duty of the magistrate does what? Stops. The magistrate will not have any jurisdiction again. The case file will now join into the DPP's office. From there, information is filed to the High Court. And then, whoever represents or the information will now be served on the defendant or on a counsel of his choice. So, later I will summarize and tell you, we have mentioned 2 things there: charge, information. We are talking about methods of initiating criminal proceedings. So we have seen that a charge sheet does 2 things. A charge sheet commands a defendant to come to court and be tried at the magistrate court. Another thing that the charge sheet does is when a capital offense is committed or any offense beyond the jurisdiction of the magistrate court, the charge sheet will be used to command the defendant to come to court, and when the magistrate declines jurisdiction, the case file will be transmitted to who? The DPP, the Director of Public Prosecutions. Right. Now, still talking about magistrate, we need to know that the methods of bringing defendants to court differ between the north and the southern part of Nigeria. In the north, there is something called first information. That was what you were trying to say. There's something called first information, and that is a provision that comes under Section 143 of the CPC. Section 143 of the CPC provides that if a complaint is made to the police, what the police will do is to take the complaint to the magistrate within the jurisdiction. And in practice, if within that jurisdiction or district, judicial magisterial district, there are like 4 magistrate districts, there are 4 magistrate courts, the admin magistrate will now look at it and assign it to any magistrate within the jurisdiction. Are you following me? Within that magisterial district or jurisdiction. Now, the magistrate to whom this information has been submitted to will look at the information, make inquiries, arraign the defendant. Let's call him at that stage, he's still like a suspect. The procedure here can be likened to the jury, procedure. The jury that is the procedure, the kind that is done in UK or in the US. In that, but the only difference is that this is a one-man show. It's not a jury comprising of persons. The idea is to do what? Find out whether there is a substance in the complaint or the information, whether there is a substance, or whether, in other words, what is the magistrate trying to find out? The reasonableness of the suspicion. So if the magistrate discovers that the complaint is reasonable, what the magistrate will do the magistrate will, with his own hand, do what? Draft a charge, charging the defendant. Draft a charge, charging the defendant. So, most of the time, people may question this kind of procedure. Does it not even amount, assuming the magistrate wants to sit over the charge, can you draft a charge and preside over it? So it will look like being a judge in your own. So, but I think it will be safer, maybe draft the charge, send it to another magistrate to handle. But then this is the procedure in the north, and it is regarded as what? First information. First information. And in other words, the proceedings here is something that can also be likened to a pretrial, a criminal pretrial. So you can also see this section 117 of the CPC law. The same thing applies even within the Federal Capital Territory. They also practice the same, they go by the same practice. So we have been able to look at charge. We have mentioned two important functions of a charge sheet. And we also talked about how a charge sheet operates in the north and in the south. Right, like in the south, it is the police that does what? Prepares the charge sheet. Police arrest, and they, upon being satisfied that a prima facie case has been committed, prima facie of crime has been committed, what will the police do? The police will now draft a charge and take it to a magistrate court. Then the arraignment notice will be served on the defendant within a period that is good enough for him to study the case against him. Right. But here what you see, the arraignment notice is not, you don't have the charge attached to the arraignment notice. What we normally see here in practice in the southern part of Nigeria is the police will just serve the defendant arraignment notice that you are required to appear at so-so-so court within the so-so magisterial district on so-so-so date to defend an allegation or provision of the offense of. It will be written, the police officer will sign, that is the arraignment notice. Then the defendant, if on bail, will take it to his counsel. Right. On that very day they come to court, the charge will be registered in the court that very morning as an overnight. It will be taken to the admin magistrate, which is normally court 1. So the admin magistrate will sign all overnight charges, sign them and distribute them to court. And then with your client, you now go to the court where your charge has been assigned to. And when you get there, the first and foremost thing to do is to apply for the bail of your client. We'll talk about that when maybe the group that will have to handle that. The person is arraigned that very day when the matter is called up. Commissioner of Police versus XYZ answers, goes into the dock, and then the charge will be brought. You are asked, do you understand English language? Say yes. Do you want the charge against you to be read in English or in vernacular? You make a choice. If the defendant makes a choice for the charge to be read in the vernacular, then there must be what? A sworn interpreter. But what at times the mistake that courts even make is that the clerk of court will double as the interpreter. But the proper thing is that even if the clerk of court has to do that, the clerk of court will have to be done what? To be sworn. And that will make her a sworn interpreter. Just summarize everything down. So we have looked at what is done in the magistrate. But if it is in the high court, what is filed is called what? Information. The difference between a charge and information is that an information contains the heading of the high court handling the matter, names of the parties, and the title, information. Then there is a preamble. The preamble states briefly that this person has been arraigned before the high court on the offense contained below. And then there will be particulars, what you call statement of offense. The statement of offense will be stated there. For instance, if that is murder, contrary to so, that is statement of offense. Then particulars of the offense will now give details of what he did for which he has been charged with murder. And then behind the information, you have statements of all the witnesses attached. If there are documentary exhibits, they will also be done what attached to the information. And even in the magistrate court, if after your client is granted bail, you have a right to apply that the contents of the case file be furnished to you so that you can adequately prepare for your client's defense. And now one other thing that private persons can also do that. If a private person wants to prosecute in the magistrate court, he goes for what? Feared. The same thing applies to if he wants information, he seeks the leave of the court by expert application. The court directs him and then gives him the leave. He prepares the information on his own and then file. That is the right of a public prosecutor. Before now, it was like a big issue whether a private person has a right to file information. So if you read Gary Foremi's book on the right of a private prosecution, you discover that the law has been settled that a private person can do what? Can prosecute even at the High Court. Now again, if a private person, being it maybe by the non-tolerance of the Ministry of Justice to charge someone to court, that private person can go to court and file for what? Mandamus. To compel the Attorney General to prosecute so person or to permit him or for the court to give him leave to on his own do what? Start the prosecution. And most of the times is that if they want to scuttle it may be difficult for you to get the case file, the requisite information you need, because you are going to rely on what? The investigation report contained in the file. The next thing you need to look at is a limitation on period. The general rule is that there is no limitation period except for some certain offenses. So if somebody commits an offense, just like in US, 30 years later, it can haunt you. Right. So the same thing also applies, only that most of the times you don't follow it. Except for treason, treasonable felonies, sedition, treasonable felonies, which limitation period is for 2 years. You must charge the person to court before 2 years. Sedition is 6 months. Then customs and exercise offenses 7 years. Military offenses 3 months after the person has left the office. Then you also look at sexual offenses. Some of them has limitation period. So what we do is by the time I will look at Group 7 work, I may also do a preview of what we have done today so that I can also entertain your questions.